Thank you for joining our webinar today on voting your proxies with purpose. Over the next hour, we will take a look at investor voting rights, what proxy voting is, why it matters, and how you can take back the vote and ensure that your ballots are being cast in your best interest. Proxy voting is a critical means by which you can influence the behavior and governance of Canadian corporations, yet many investors, including Indigenous trusts, delegate proxy voting to their investment managers, often with minimal oversight. Before we jump in, I'd like to gratefully acknowledge that we're broadcasting this webinar from the traditional unceded territories of the Musqueam, Squamish, and Tsleil-Waututh Nations. Mark is joining us from the Six Nations of the Grand River Territory. And we're grateful to have participants joining us from across Turtle Island today. To start, we'll offer a bit of background on the organizations represented here today. Your speakers today are myself, Katie Wheatley, Project Lead for the Reconciliation and Responsible Investment Initiative, Mark Savest, Founding Member and Senior Advisor to NATOA, and Shannon Rohan, Chief Strategy Officer at Share. Founded in 2000, Share is a leading nonprofit organization in responsible investment. For the past 20 years, we've worked with a broad network of institutional investors, including Indigenous trusts, pension funds, universities, religious organizations, and foundations, to implement responsible investment strategies and to amplify their voices in support of a sustainable, inclusive economy. Mark, do you want to tell us a bit about NATOA?
Thanks, Katie. Yeah, NATOA was founded in 2006 by a group of Indigenous trust managers who felt that a formalized network to help each other in the area of trusted investment was necessary. So we created that organization to provide education, capacity, and knowledge to our communities who are investors. We are happy to have been partnered with Share to create the RRI program for the last several years and working towards becoming a very strong, vital economic partner within Canada. So thank you very much.
Thanks, Mark. And the Reconciliation and Responsible Investment Initiative is working with both Indigenous and non-Indigenous investors to help build capital markets that integrate and better align with Indigenous values, rights, and ways of knowing. Before we jump in, a few quick housekeeping matters. So we're keen to make this an interactive experience. You can send us questions through the chat box in the lower half of the GoToWebinar panel at any point, and towards the end of the webinar, we'll open up the discussion and look to address any questions that have come in. At that point, you'll also be able to ask questions directly via microphone by clicking on the hand icon on the webinar panel. We can then activate your channel so everyone else can hear the question. Finally, please note that we're recording this webinar and it will be made available via our website, reconciliationandinvestment.ca. First, we'll turn to Shannon Rohan, who will share what proxy voting means, how it works, and how asset owners can effectively steward their capital through proxy voting.
Great, thank you so much, Katie. It's great to be here today, and thanks to all of you who are joining us from across the country. What I want to talk about this morning, just for a few minutes, is to provide the foundation for the conversation today around what is proxy voting, how do you set up a proxy voting system for your trust or your fund, and why is proxy voting important? And so we'll go through a bit of that, and then I will hand it back over to Katie and Mark to do a bit of storytelling and to tell us about a specific vote that they were involved in. So as you know, most common stock carries the right to vote at shareholder meetings. So when you own shares in a company, those shares come with the ability to vote at meetings that happen, either annual meetings or special meetings that the company holds. Shareholders can attend the vote in person, but most voting on company business is done by proxy. Investment managers or a voting service may be delegated to vote on a shareholder's behalf. And some of the things that shareholders vote on are things that are put forward by management and are often referred to as regular business or ordinary business of the company. And that includes election of directors, for example, appointment of auditors, executive compensation, or what's otherwise known as say on pay. And so those are important items that shareholders are voting on. The other issues that shareholders are voting on at these meetings are issues that are put on the agenda by shareholders themselves. Often these issues relate to what are known as environmental, social, and governance issues, and include items related to human rights, to Indigenous rights, to decent work, to environmental protection, climate change, carbon emissions. And a lot of those items are asking companies primarily for better disclosure and transparency around how they're dealing with those issues, but also those proposals are asking for better oversight by corporate boards, for example. They're asking for improved policies and practices. And so those are some of the things that we're seeing on the ballots at company meetings where you are voting your proxies. How are your proxies being voted? Oftentimes, the most common way that your proxies are being voted is that it's delegated to your investment manager. And so they're executing those votes on your behalf. Some funds may hire a third-party proxy voting service, and they will do the voting on your behalf. And so rather than your manager doing it, you actually have a third-party service provider doing it. There are companies out there, including ISS, for example, which you may have heard of. Glass Lewis is another, and SHARE, actually, the Shareholder Association for Research and Education, where I work, we also do proxy voting on behalf of a network of investors. When you get to quite big and large size funds, mainly pension funds, you will see that some of them do vote in-house, although they often rely on and purchase data and research from others, including the proxy voting service providers. And I just want to talk a little bit about the differences with regards to pooled versus segregated funds. When you're in a segregated fund, you own the underlying shares of the companies in your portfolio. And so with that, you do have the rights directly, the voting rights related to those companies. If you are, however, in a pooled fund, you own units in that pool. So you don't actually own the shares directly, and so you don't have the ability to direct the voting rights. However, I think it's really important to note that the way the pool is voting is still relevant to you, and the oversight of proxy voting and talking to your managers on how the pool is voting is still a very relevant and important conversation. And so we'll talk a little bit more about that later, but I just want people to understand that raising voting, whether you're in a pooled or a segregated fund, is really, really important. And we've seen individual clients who are part of a pooled fund influence the way that the entire pool is voting. And so again, using your voice as a participant in a pooled fund around proxy voting is still really, really important. I want to move on to talk about why proxy voting is important. And I spoke a little bit about this, but I think it's really important to understand that the voting rights that come with being a shareholder are a valuable asset for your trust or your fund, and for all asset owners, actually. And as trustees, you have an obligation to ensure that the shares owned by the fund are voted in a way that supports the interests of your beneficiaries and your communities over the long term. So the trustees of the fund and anyone appointed to vote your proxies, so your investment managers, for example, do have a duty of loyalty to exercise a proxy voting authority with the prudence, skill, and diligence that a prudent person would exercise in managing the property of others. So this does fall into the fiduciary duty of trustees. So oversight of voting is an important aspect of that. Failing to vote the fund's shares, for example, or voting without consideration of the effects of the vote, or voting arbitrarily either with management or against management does violate this fiduciary duty. So it's really important that we do have active oversight of the way that our proxy rights are being voted. And the final third reason why proxy voting is important is really about voting influences corporate behavior and allows you to have a voice around the issues that are coming up on the ballot. So both issues that management is putting on the proposal on the proxy ballot in terms of executive compensation, in terms of election of directors, appointment of auditors. Those are all really important matters. And so your vote does influence how companies are approaching those issues. And also, on the other hand, the issues that shareholders are putting on the ballot are also equally important, that you're overseeing those voting rights, and those voting rights are being used in your best interest. And it really does make a difference in terms of communicating with corporate boards and management about these important matters that do affect corporate governance. They affect corporate performance and the overall management of issues that companies are overseeing, and that includes human rights, for example, Indigenous rights, environmental protection, among other things. So I want to hand it back over at this point to Katie and Mark to delve a little bit deeper and provide us with a tangible example of why proxy voting matters. And so I will turn it back over to Katie, who will tell us a bit of a story.
Thanks, Shannon. So now we're going to look at a case study to illustrate how voting on company resolutions can help improve corporate governance. One example that occurred recently that might be of interest to this group was a shareholder proposal that was filed at the Bank of Nova Scotia, or Scotiabank, this spring. So this proposal focused on the consideration of potential impacts on human and Indigenous rights, including respect for free, prior, and informed consent of Indigenous communities affected by Scotiabank's financing. Scotiabank lent money to companies that financed and built the Dakota Access Pipeline and the expansion of the Trans Mountain Pipeline. Yet violations of human rights can expose a company to liability for those issues, even if the company does not participate directly in such abuses. Scotiabank had exposed itself to this liability by providing financing for oil, gas, and coal development projects entangled in Indigenous rights violations, including the failure to obtain free, prior, and informed consent through various project and corporate level loan agreements. The shareholder proposal that we saw this year requested that Scotiabank revise its human rights policies to ensure that in all project finance and commercial lending settings, the bank thoroughly consider recipients' policies and practices on human and Indigenous rights, including respect for free, prior, and informed consent of all Indigenous communities affected by the financing. Some proxy advisory services recommended that asset owners vote against the proposal. They pointed to Scotiabank's mention of Indigenous rights in their human rights statement and posited that Scotiabank had gone far enough because they're a signatory to the Equator Principles, which are a risk mitigation framework applied by financial institutions in their credit risk review process to avoid complicity in abuses and environmental harm through their lending. Unfortunately, the Equator Principles do not include an adequate risk assessment process on Indigenous rights. These principles also do not apply to all the countries in which Scotiabank operates, such as the US, and do not commit signatories to implement the UN Declaration on the Rights of Indigenous Peoples, nor to obtaining free, prior, and informed consent. From our perspective, by not including the UN Declaration on the Rights of Indigenous Peoples in its human rights policy, the bank risks ongoing liability for the violation of Indigenous rights. These risks include the potential for legal liability, for financial losses, and damage to the risk's reputation. Changes to ensure that Scotiabank respects free, prior, and informed consent would help the bank mitigate that liability, improve its regulation, and show Indigenous communities and decision makers the respect that they deserve. As a result of our analysis of the proposal, NATOA and SHARE issued a proxy alert through the RRII network. This went out via our mailing list and on our website, recommending that shareholders vote for the proposal. The proposal went to a vote at the bank's AGM on April 7th. It received 8.89% of the vote this year, which is a bit disappointing. It's critical that shareholders use their votes on ballots like these that align with their beneficiaries' interests and values. Good vote results reinforce that Indigenous rights are an investor priority and help push for improved corporate practices. Mark, I'll turn it over to you to tell us a bit about the Mississaugas of the Credit First Nations experience with this proposal. And hopefully you can share any insights you might have on talking with our investment managers about proxy voting.
Yeah, thanks, Katie. Well, first I'll say that these votes are, as Shannon mentioned, these votes go on all the time. And as Indigenous investors, are we aware of that? The idea that the proxy voting was an important element was something that we had been discussing for some time. I'll give credit to my colleague and board member on NATOA, Jason Campbell. I think he's on the call here today. But initially, it was his comment at one of our conferences, and something he said to me early on when we first met, is you got to know what's in your portfolio. And I think as Indigenous investors, trustees of Indigenous trusts, that we have to take some time and look through our portfolio, if not to just familiarize yourself with what you own, because the value of the portfolio is not only in the assets that you generate, the revenue you generate for your community, but how those assets are generated, that revenue is generated. It's a reflection of your community values. So a few years ago, through the work that I've been doing with NATOA and with Share on RRI, I brought forward to my trustees in new credit that we have to revise our investment policy, because in our existing policy, our previous policy, we had the ability to vote our proxies and direct our managers, but there was not very much of a onus on our trustees to actually take responsibility for that. So we believe that the knowing what's in our portfolio and understanding that these votes come up and having our say was very important. My trustees recognize that. So we made amendments to our policy, and I've shared the proxy voting section with Shannon and Katie that we can share with you if you're interested in looking at it. But really, it put the onus on our trustees to know what was in our portfolio, to proactively look at what types of votes were taking place, and especially in cases where Indigenous issues were specified in these votes. We made it mandatory for our investment managers to make us aware of that when they did, or if we came across it, we would let them know. And so this is how it came up. One of our managers sent me an email saying that this vote was coming up with Scotiabank, and I knew in our portfolio we have 2 investment managers. I knew that both managers carried this Bank of Nova Scotia stock in both portfolios. And looking at the rationale, as Katie had mentioned, that the proxy voting service would have said, vote against it because everything is cool, they're all right. I made sure our managers knew that I was part of an Indigenous group that were providing recommendations to the consultation or consultant who was redrafting or drafting the revisions to the Equator Principles Association over last summer, that we wanted to have those principles at least meet the standards set by the United Nations Declaration of Rights of Indigenous People. We thought that where the Indigenous rights were part of the Equator Principles were sorely lacking, and unfortunately that standard was not approved when the Equator Principles Association voted on the revisions. So when part of the analysis by the proxy voting service was saying that the Scotiabank's reliance on the Equator Principles Association guidelines was good enough, and I said no, that's not. And I think in our case, my trustees agreed wholeheartedly that on one hand we are stepping up and exercising our rights and our support for Indigenous communities, in terms of a corporate entity having an impact on the lending side and the companies that they're lending to. What is their background and what is their policies and practices in the Indigenous community? So we're protecting ourselves that way. The other part of it too, and I spoke with, was fortunate enough to speak with the national manager of Scotiabank, and he'd seen our recommendation. Explained to him our situation, and I said that this is nothing contrary or nothing that we're trying to punish or rebuke Scotiabank for. What we're trying to do is protect our investment in that company, because we feel that the liability that they've exposed themselves to and the loss potentially, because in these cases, you know, the projects will be delayed, the projects could be denied, the projects could be stopped, and that's a loss of revenue for Scotiabank, which turns into be a loss of value for us. So both we felt it was important to exercise our ability as a shareholder. And had we not been informed of this, this vote would have gone through, and our votes would have been voted against that. And that was totally unacceptable for us. And I was able to get a hold and speak to the investment company that was bringing this proposal forward, and thank them for doing that, and said to them that it's, you know, in fact, embarrassing for us as Indigenous people to have some non-Indigenous investor standing up for our own rights while they're not even aware of it. So I think that we took upon ourselves to make sure we stepped up. We passed a motion on our board table and to support this, and it was noted at the Scotiabank AGM that the Mississaugas with the Credit Board of Trustees supported this wholeheartedly. So we are on record in supporting our rights and supporting our stake in the Scotiabank. So I think it's important that we talk to our managers. I would challenge anybody out there, if you had Scotiabank stock in your portfolio, how did your stock and your managers vote on your behalf? You can ask them, and if you disagree with what they, how they voted, if they voted in fact with the I believe 92% that voted against this, you know, those are your shares, that's your voice. So I would say that it's very important to have a discussion with your investment manager in this area, especially. And if there are, and in this case, this was Indigenous rights, and but there may be other things too that be of value to climate change, environmental. So have those discussions with your manager, and if you are interested in having a discussion on how you change your investment policy, or how you have a better, even how you approach your investment manager, we're always happy to be here to assist you in that. So give us a call, send us an email, and we'd be very happy to work with you on that. But you know, the bottom line is the revenue that you generate off of the money that you're entrusted with as an Indigenous person is a reflection of your values. And you can go back to your beneficiary and say, I've stood up for what we believe in and who our community is. So with that, I'll give it back to Katie, and just so happy that we're having this discussion today.
Thanks, Mark. I think we're going to turn it over to Shannon now, and she'll be telling us a bit more about how to talk to our investment managers about it, and different insights on how to start these conversations and potential resources that we can look to for support.
Great, thanks so much. Yeah, what I want to do is draw out some of the comments that Mark was making in terms of how do we actually do this? What are some next steps that you can take with your trust to better understand how your proxies are being voted, and to ensure that you have the oversight framework in place to ensure you're meeting your own duties and effectively overseeing how your proxies are being voted. And the first step really, I think, builds on what Mark was saying in terms of know what's in your portfolio, and that's really learn how your fund's proxy ballots are being voted, who's voting them, if it's your investment managers, do they have proxy voting guidelines that establish a framework by which they're making those decisions? If they do have guidelines, it would be great to ask for a copy of them, and to take a look at where they stand on issues that are coming across the ballot. You can look at whether the guidelines have any guidance related to environmental issues, to social issues, to human rights and Indigenous rights issues, for example. So that is a good starting point. The second is to make sure your approach to proxy voting is outlined in your investment policy. And so that's really what Mark was talking about in terms of the key steps that his trust took, was to make sure that their approach to proxy voting is actually laid out in the investment policy statement. And I'll go into a bit more about what that might look like in the next slide. The third really key step, I think, is to initiate a conversation with your asset managers or your proxy voting service agents. For many of you, that will likely be your asset managers, and talk to them about their approach to voting. If you aren't getting regular reports from your managers on how they're voting, it would be great to incorporate that into their regular reporting to you. So that can either happen on a quarterly basis, for example. I know some do it more on an annual basis, but regular reporting on how your proxies are being voted is really, really important. And it's also important to look at the content of that reporting, because if you're just getting the proxy voting record, you'll receive this enormous pile of paper with all of the ballots that were cast on your behalf. And that can be really, really hard for a board of trustees to go through and understand. So asking your managers to draw out some key data points from their voting record is really, really valuable. And some of those data points might be, for example, asking them for the percentage of votes that they cast in with management, so where they voted in with the management's recommendation for that proposal, versus the percentage of votes that they cast against management. So that gives you a sense, just if they're voting 100% with management, are they really taking the due diligence required in analyzing each vote, that's coming across the ballot? There are reasons to vote against management, and that might be associated, for example, with auditors. If auditors have been the same company for a long period of time, some might think that that doesn't have the independence required for the role of the auditor. So there are guidelines that many organizations would have, that would say if auditors are in place for over 5 years, we will vote against the appointment of the auditor. Similarly, there are expectations around independence of directors, for example, and you'll see some people voting against directors if they don't perceive that they have sufficient independence to act in the best interest in terms of their role on the board of directors. So there are reasons to vote against management, and it's valuable to get sort of that high level data from your managers. You may also ask for information from your managers on the percentage of shareholder resolutions that they voted in favor of. So as I said in my opening comments, your proxy votes are related to issues put on the agenda by corporate management, but also issues that are put on the agenda by shareholders. And so understanding how your managers are voting when other shareholders are raising issues and putting those on the agenda is another valuable data point. I would also recommend, in terms of the fourth point, incorporating proxy voting into your asset manager hiring and monitoring. So I talked already about the monitoring piece, and inviting people to make sure their managers are reporting on a regular basis on their proxy voting. But also, if you're going out into a new hiring process, including proxy voting in that RFP can be very, very valuable. And that can, as I said, include asking the managers to share their proxy voting guidelines, asking managers to share their approaches to proxy voting, asking managers to share some high-level data points as part of that RFP process can be an additional helpful insight when you're looking at hiring. And finally, there is an ability to be proactive and to, be aware of issues that are coming up on the ballots of companies that are in your portfolio. And this kind of information will, for example, come through the Reconciliation and Responsible Investment listserv. If you're not signed up to that, we highly recommend that you do. And also through Share's own listserv and NATOA's listserv. We'll be putting out information about votes that are coming up on the ballots of companies that may be of interest and that you may hold in your portfolio. When you get that kind of information, and we often call them proxy alerts, it's very valuable for you to take that and send it to your manager and ask for their analysis. How do they intend to vote on that particular issue, and what's their analysis? So that can be a helpful way to initiate a constructive dialogue with your asset managers. And what we've actually found, I think, in terms of inviting people to initiate a conversation with their managers about proxy voting, is that many managers will actually respond and be really pleased that they're able to share information of their approach to proxy voting with you, because often they don't get asked about that information, but they are investing quite a bit of time and resources into their analysis. And that's a really, really good sign when you're asking your managers for information and they're actually quite pleased to share it with you and can provide a lot of information and they just hadn't been asked before. So often we find that leads to quite constructive conversations. In the next slide here, I just want to go into a little more depth around what Mark was alluding to in terms of the steps that his trust took, and that was to go back to their investment policy statement and to include information about proxy voting oversight. And as I said, it's really important that you establish your proxy voting system and articulate that clearly in your investment policy. And these are some of the things you might consider if you're looking at including proxy voting in your investment policy. First, you want to make sure that the policy enables you to delegate voting to a third party. And so that would ensure that your manager or a third party proxy voting service could vote those proxies on your behalf. You also want to make sure that the policy talks about your expectations with regards to record keeping for your asset manager or the proxy voting agent that you have, so that they're keeping records of all votes cast on your behalf, and that you're getting regular reporting from your manager or reporting voting agent. And I would say that the regular reporting is really important, whether you're in, again, a pooled fund or a segregated fund. So getting the reporting from your managers is really important on both sides. The other step that, principle that you could include in your voting policy is around getting advance notice on votes that are of particular interest to your trust. And this is something that Mark spoke about and that his trust did, and that was to ask their managers in their segregated funds to give them sufficient notice on votes that related specifically to Indigenous peoples or impacts votes that relate to impacts on First Nations or Indigenous people, or votes related to Indigenous people's rights, for example. And so that's what triggered the investment manager to bring the Scotiabank vote to the attention of that trust. So that's really, really a valuable piece that you can include in your investment policy, and you can define what what votes you really want to pay attention to. They might be more broadly related to issues of environmental protection, or they might be narrowly related to anything to do with Indigenous rights. And finally, just as the policy would allow you to delegate voting to a third party, you want to make sure that you retain the discretion to direct proxy voting if the board chooses to do so. So again, when you're in a segregated fund, you do have the ability to retain the discretion and to direct how a proxy is voted on your behalf. Again, this was something that was put into practice by Mark's Trust, as he talked about for that Scotiabank vote. So they ended up directing their manager to vote in favor of that proposal. And so that was facilitated because this sat in the trust's investment policy. And so I actually just wanted to go back and ask Mark to tell us a little bit more about the process that you went through in revising your investment policy, Mark. If you can talk about, was it a part of a regular review of your investment policy that you were able to make these changes? What kind of support did you get in order to do so? And were there any other changes at that time that you made to your investment policy? If you can just give us a picture of the steps you actually took to adapt that policy, that would be great.
Sure. Our initial policy was revised in 2006, and so it sat working under that auspices for a number of years. It wasn't, we'd look at it every once in a while, but once we started doing a lot of this work and a lot of the discussions on the value of the investment and the asset it is, we recognize that the proxy vote is an important asset that we retain, and the ability to direct our will into that was something that I'd had discussions with my trustees over a number of years, and it was probably in 2008 we started the discussion very strongly in 2016, saying we need to review and revise our investment policy. We didn't do this in a vacuum. I reached out to my investment managers directly and said, what within this is working and what within this would you like to see change based on your experience. Reached out to an investment advisory service that we've been utilizing. I also reached out to Shannon and some of my friends that share for their input as well. And it was a lot of the shareholder proxy stuff that I got from you, Shannon, that I appreciated. And we were able to revise that because we recognize that as I said, the revenue that you generate off the funds has to be a reflection of your values. And I think that the ability to have an input in the management of companies for our benefit is something that needed to be done. So it took about a year and a half to get the investment policy revitalized. We changed a bit of our asset allocation based on the input we got from our investment managers, and but generally the biggest change was in the proxy voting. I really stressed to my trustees that this is their responsibility, and for them to stand in front of their community members at our community meeting or at any time is a way of it for them to say, we are proactively looking out for your best interest and the best interests of our community. So we thought this was a fantastic way to do it, and I'm really so proud that our community trust was reflected in the presentation to Scotiabank, that it's not just a group of non-Indigenous shareholders saying, we think we'd like you to do this. This was actual input from shareholders who are Indigenous, speaking out and providing input. And I will say that the nice part about it is that Scotiabank reached out to me directly, and I'm hoping to still have some discussions with them in this regard moving forward, even though the shareholder proposal itself didn't pass. But hopefully we've opened up a dialogue and can get something moved forward, just to try to provide them with the background of why it is important for us that they do this. And of course, why it's important for them that they do this as well.
Great, thank you, Mark. I just have a couple of more slides that I want to go through and want to take a moment though to remind people that we are coming up to question period. So please get your questions into the chat box on the right-hand side of your screen and we can make sure that those are queued up. And I just wanted to talk about some resources that are available to you and that may be helpful. The first are a couple of proxy voting guidelines that are publicly available that you can take a look at, download, share with your managers, and these guidelines are quite extensive, particularly in the areas of environmental and social issues. The Coast Fund's proxy voting guidelines are very, very interesting. They went through a process similar to the process that Mark outlined in really trying to understand how they could more effectively oversee their proxies and how they were being voted. And they were particularly interested, similar in Mark's trust, to making sure that they were voting in using their voice as shareholders and using that influence to vote in favor and in support of any resolutions that were coming up related to protecting Indigenous people's rights, protecting traditional territories and land, any resolutions that were speaking about representation, ensuring broad representation of Indigenous people on corporate boards, for example. And so they went through a process and with support from Share again and from their investment consultant in developing these guidelines. And you can find those at the Coast Fund's website, which is provided on the slide there, but I'd be more than happy to send them directly to anyone who's interested in seeing them. Similarly, you have the URL there for Share's guidelines, which are much, much broader. They address a broad range of corporate governance issues, environment issues, and social issues. And again, I'm more than happy to send those directly to anybody interested. And the third one here is just to get in touch with us to find out how we can support your trust particularly and give you some guidance in terms of the unique circumstances of your trust and how your proxies are currently being voted. And so that's an invitation to get in touch with us directly. And I also just wanted to give you a sense of other issues that are coming up on the ballots of companies. And these issues are two examples of shareholder proposals that will be coming up on the ballot of these two companies. The one is formerly Encana Ovintiv, and the shareholder proposal being put forward there is asking the company to make its plans clear for meeting industry-wide emissions reductions targets under the federal targets and the Alberta Climate Leadership Plan. And so this is a proposal that Share is working with along with members of our network to essentially ask the company for greater transparency and better disclosure. In terms of trying to understand how companies are adapting and adjusting to the transition to a low carbon economy, it's really important that we see what their pathway is and what their targets are in terms of emissions reductions. And so that's what that proposal is asking for. It's asking for better transparency so investors can make informed decisions. The second proposal I wanted to just provide as an example is one that was filed by one of Share's network members, the Atkinson Foundation, and it was filed actually at a company called Restaurant Brands International, which is the owner of the Tim Hortons franchise and brand. And that shareholder proposal is related to decent work, and it's asking the company for more information on how it's upholding decent work practices and standards across its operations and specifically across its franchisees. And so the kinds of things we're looking for is information related to wages, benefits, working hours, paid breaks, for example, health and safety, and scheduling. And that proposal emerged as a result of some of the actions that were happening at certain Tim Hortons locations where the franchise owners were cutting workers' paid benefits, for example. There was practices happening where people were only getting their schedules at a very short-term notice, making it very difficult for the Tim Hortons workers to organize childcare, for example, and other obligations. So those are two proposals that are coming up on the ballots of these companies. If you're interested in receiving more information about them, we'd be more than happy to send those through. But I want to turn it over now to some questions from the audience, and I'm going to hand it back over to Katie. But first, I'm just going, I have a question actually here for Mark and Katie, so I'm going to read this out. The question is for both Mark and Katie. You both referenced the case of Scotiabank during the current proxy voting season. Were there any other examples of specific resolutions involving Indigenous issues during the current proxy voting season in Canada? So are there any other votes that you're aware of that are coming up on the ballots of Canadian companies related to Indigenous issues or Indigenous rights? So I'll hand that to either you or Mark. Katie.
I'm not aware of other cases at this point. I know that in previous years there had been filings, for instance, at TC Energy, formerly TransCanada, on Indigenous rights around similar issues of due diligence on Indigenous rights prior to pursuing projects. So that one was filed last year at TC Energy, and a couple of years ago there was one filed at Enbridge around similar matters relating to fallout from the Dakota Access Pipeline, looking to have Enbridge make greater commitments to do proper due diligence before engaging in development projects that might impact Indigenous rights and territories.
Yeah, I'm the same. I have not been made aware of anything as directly in regards to Indigenous rights as the Scotiabank vote, but I'm still interested in hearing if there are any more.
Katie, do you want to talk a little bit about, just to give people a sense of the proactive engagement that Share is leading with its network? Even though these issues aren't necessarily on the ballot, it's, I think, important to talk a little bit about the upfront work that people are doing to get these issues on the ballot. And can you just give us a very high-level overview of the engagement work around Indigenous rights and reconciliation that is going on right now?
Sure. So this year, actually, at Share, under our engagement program, Indigenous rights and reconciliation are one of the 4 major themes that we are focusing on. So this is alongside just transition and decent work, other commitments and priorities for us. But basically, it's important to recognize that advancing and filing shareholder proposals, taking these things to a vote, that this is one lever in a way that shareholders have, but engaging directly with the company is another one. So the Scotiabank case is interesting, and it's important to recognize that these ballots are being cast in our interests because good results at votes like these can help trigger further conversations and improvements within the corporate governance of companies, but that's definitely not the only approach that we can take. So Share engages with around 10 companies a year to talk specifically around their commitments relating to Indigenous rights, to reconciliation, to strengthening the Indigenous economy, and more. So we are really looking on an ongoing basis to have companies take the pen and improve their policies around reconciliation and Indigenous rights. We like to see companies really across the TSX build in commitments to set-asides and procurement advantages, and basically strengthening Indigenous businesses by ensuring that they're adding to the Indigenous economy, that they are providing opportunities for Indigenous entrepreneurs and small and medium-sized enterprises to get engaged in their work when they do have to contract out pieces of work. We're also looking to see that they are prioritizing Indigenous representation within their boards. We're looking to see disclosure around Indigenous representation within their own employee base. So how many Indigenous people do they have employed? And is that representative of the region in which they work, of the level of Indigenous peoples within the sector that they're operating? So we're really looking to see corporations move the dial on reconciliation and Indigenous rights in meaningful ways. And that work is done year-round.
And if I could just add that last year at our NATOA conference, Shannon had offered to work with Indigenous trusts as a pilot project for their Values and Action program. And happy to say our trust was the first one to join in. There's 2 others that came on as well. But I think what Katie's referring to is the engagement that Share is doing with companies and providing us a quarterly report of the progress that they're making. And if there's anything that we want to jump on board with and lead, we certainly have this venue, and this is how the ability to influence the corporate Canada, in our case, from the perspective of a shareholder to, as Katie was mentioning, the procurement, the employment, the getting Indigenous people represented on their boards is an incredible way to foster the Indigenous economy. NATOA was part of 4 organizations that are supporting the Indigenomics Institute's call for $100 billion Canadian or Indigenous economy in Canada, and this is our contribution to that progress or that project process, where CCAB is working with corporate Canada, NACA is working with the entrepreneurs that could be part of the procurement and pipeline to increase this economy. So it all works together, and I think this is the avenue and where we didn't have the experience and knowledge of exercising our shareholder rights. I think this is the value that we've been able to get from our partnership on the trust level with Share and this group. So the Scotiabank vote just kind of dropped into our laps based on some, the work that we've done, but I think it's all important.
Great. Thank you, Mark. Another question has come through with regards to establishing specific proxy voting guidelines and whether it's common for asset owners to establish their own guidelines and what types of special provisions are often included in those. So I can take a stab at answering that. It is quite common to see asset owners developing their own guidelines. I think you typically, if you look at some of the big public sector pension plans across the country, for example, you certainly see that they have their own guidelines. But we're also seeing smaller funds also taking those steps, as I mentioned, with Coast funds to develop their own guidelines, take those guidelines and to their managers and ask that their votes actually be cast according to those specific guidelines. In the case of Coast funds and probably for other smaller funds, there are special provisions related to issues that are particular to that fund. So for Coast funds, they have certain values and wanted to make sure there was an alignment with the values and beliefs of Coast funds and the communities that they're investing on behalf, and the way that they're casting votes that affect specifically Indigenous peoples. But other areas that we might see where people want to have specific guidelines would be around executive compensation. I would draw attention to specifically. For example, SHARE has a lot of provisions and guidelines related to executive compensation that relate to income inequality, for example. So if we're seeing certain multiples of executive compensation that are more than 200, 300 times the median wage in Canada, or in the US where we're actually getting pay ratio disclosures. So companies in the US actually have to tell us the executive compensation of the CEO compared to its average employee wage. And, in some US companies, we're seeing 900 times, 1,000 times. When we see those kinds of numbers, based on SHARE's guidelines, we're just voting against that executive compensation package. And so you will see that certain asset owners and certain funds do want to make sure they're not sort of voting across the board in favor of these types of executive compensation packages, particularly when they're concerned about inequality, concerned about situations where there's a huge layoff. We've had situations where companies have laid off 2,000 workers and yet the CEO still gets an enormous bonus. From the standpoint of SHARE and our expectations in terms of what we want to put forward for a more sustainable and inclusive economy says that if you're laying off workers, you're not at the same time rewarding CEOs with huge bonuses. So those are the kinds of things that certainly SHARE is putting in its own guidelines, and that we're seeing more and more asset owners also including. So I don't know if Mark or Katie want to add anything to that. I have another question here. I've reviewed the proxy voting guidelines of Coast funds, which were approved in May 2019, and will the results of the proxy votes of Coast funds during the annual general meeting season be made publicly available? So that's an interesting question, and I'm not sure if Coast funds will, make their voting record public. It's certainly something that we could ask Coast funds if that's something they thought about. We do see that large, certain pension funds, for example, will release their voting record, and BCI is a good example, but there are others across Canada that make their voting record public. And so I'm not sure that Coast Funds has considered it, and how that would work exactly in terms of with their investment manager, but it's certainly something that I can follow up with Coast Funds on. And if you want to contact me offline, we can pursue that conversation and see what they say. I'm just seeing if there's any other questions. I don't see any more hands up or any other questions coming through the chat box. And so I would invite Katie and Mark, if you have any last minute comments. We're just 3 minutes before the hour, so it's quite good timing. And if you have any last comments you want to make, please go ahead.
Well, I'll go ahead if you don't mind. I'll just say that I'm really pleased that we were able to do this today, and the idea of having these discussions is important for us. As I mentioned before, the funds that we are entrusted with by our communities to invest have to be a reflection of the values of our community, and that comes out in two ways. First, it's the selection or putting together the parameters within your investment policy of the selection of the stocks in the first place. You certainly don't want to invest in companies that are doing harm, and especially doing harm in your traditional territories or somebody's traditional territory. So I think a good way of avoiding that is the selection process in the first place. But secondly, how do you make a change? Well, there's always the discussion of divestment versus action. And I think divestment is probably the last step. I think engaging with the company on the shareholder level is probably the first and most important way to be able to have an impact and to assert your values and assert your opinions on how a company should be operating, especially within traditional territories. So this is a great opportunity for us to be able to go back to our community members and say, this is what we're doing on your behalf, and we're utilizing the rules and the process that's already in place that's been utilized by other investors for years. We're just now opening our eyes to this. I had a nun at a meeting I went to come up to me and put her hand on my shoulder and said, you guys are voting your proxies, aren't you? And this is a few years ago, and I said, no, at this point we're not engaged in that process yet, but we will. And I think through this process we will get that word out, and hopefully everybody understands how vitally important this is. So from Six Nations here, I just want to say thanks to everybody for being here with us today.
Thanks, Mark.
Sorry, I know we are, I think, right on time, but there was a question here that I missed. For pooled funds, how does that work? Is the report different in terms of asks of investment managers? So I just want to address that briefly, Leslie. I hope that you're still on the line. Yes, the conversation is different. But you can certainly still be asking your investment managers for your pooled funds if they have guidelines. If so, can you see them? If there are votes coming up in the pooled fund, you can certainly raise concerns or ask the manager how do they intend to vote. We have seen pools change their vote as a result of one of the pool members asking questions and raising concerns. So you still have influence there, even though you don't have the voting rights. So it's still important in that context that you're asking those questions. Another comment for Mark, keep talking to Scotiabank. A 10 to 20% proxy vote can be enough to change company behavior. So I agree, you know, an 8% vote is not insignificant. It is 8% of its shareholders. And so as Jeff is encouraging us here to keep that conversation going. So thank you for that. So that, I think now I've gone over. I was so proud of 1 minute over, but I'll hand it over to you, Katie, to close us off.
Great. Thank you both so much, Shannon and Mark, for helping to really shed light on the fact that proxy voting is an undervalued yet critical tool and right that investors can use to align their capital with their own values and beliefs. There are other important votes coming up this proxy season at Loblaws, Amazon, Alimentation Couche-Tard, Dollarama, and more, many of which would be of interest to you. So we'd encourage you to go back and talk with your investment managers about these. Proposals like these are critically important, especially today in light of the COVID-19 pandemic, where we're seeing that more stable and well-managed companies with good environmental, social, and governance practices have been better equipped to respond to the crisis. If you'd like to learn about any of this more or any of our other work, please visit our website at reconciliationandinvestment.ca. You can also find us on Twitter at IndigenousRI for the latest from our team. And to hear about more upcoming events and action in this space, you can sign up to our listserv if you haven't already by visiting our website. And again, do please feel free to get in touch personally if you have further questions about this or other aspects of our initiative. For instance, we can come and talk to your trustee board about how your proxy votes are being cast and other aspects of your investment policies and oversight and more. Thank you.
Thanks, everyone. Have a good rest of your day.
Be safe, everybody.